One of our favorite secret weapons for problem solving and negotiating is local real estate attorney Brian Lytle. In this series of Get Smart, Brian shares insights on parties.
Hi, I'm attorney Brian Lytle, and in today's Get Smart segment, we're going to take a look at the parties to the contract. Before we begin specifically, this is not specific legal advice. That's always fact dependent. This is just a broad overview. And I'd like to note that in the Lismore and Associates geographic area, there are three different contracts used. There's a RAIN contract on the peninsula, the CVR contract in the Richmond area, and the VR contract used statewide and specifically in the Williamsburg area. Each of those contracts handles some things a bit differently. But all the contracts are fairly drafted for both buyers and sellers, and in that way, your Lismore agent can use the same contract whether he or she is representing you as a buyer or you as a seller. Again, the specific purpose of this Get Smart segment is an introduction to the parties, identifying them in the contract. And if you have any questions, you should ask your Lismore agent. Turning to the details, you'll see on the screen a sample parties provision, and this one is from the Virginia Realtors contract, the one used in Williamsburg. But again, they're all pretty much the same. So what we're fundamentally doing here is identifying who the parties are. We will, in the first part of it, we're going to identify the seller, and that may simply be the name, and the most common thing, of course, is the name of the seller, individually and personally, if that's in fact the seller. It may be Brian D. Lytle, for example, or Brian D. Lytle and Brenda N. Lytle, husband and wife, that sort of thing. And of course, there may be a trust, and there may be a corporation as a seller. There may be an estate involved. And in that case, there are other Get Smart segments that deal with that specifically because it gets pretty complicated. From the purchaser standpoint, it's the same thing. You're just identifying who the purchasers or purchaser is or purchasers are. And then in most of the contracts at this point, we're noting who the agents are and who they represent. So that, it's fairly straightforward. I don't know that you really need to be a lawyer to understand that. But just some particular issues and tips. Make sure that the correct names are listed. You should be matching the deed for the sellers. That is, all the parties identified on the last deed should be noted. From a buyer's standpoint, we want to make sure that the names match the identification, typically a driver's license, an operator's license, and want to make sure that the lender has the same thing. All too often we see a contract where the name listed for the buyer is one thing, maybe with a middle initial, without a middle initial. The lender's got it a different way, and it can create some provision or confusion, I should say, near settlement in terms of getting things notarized. So let's try and make sure that's consistent and correct at the beginning. Entities, that is corporation, limited liability company, and LLC. I want to make sure from a seller standpoint, make sure that that's correct. It's the correct name. It's designated if it's a corporation. It's not called an LLC if it's not, that kind of thing. As far as estates go, again, that's pretty complicated, and we've got other Get Smart segments to help explain that. And just a note here, if you're a purchaser and you think you may want to assign the contract and take title in a different name, typically we say and/or assigns. That's the typical language that's used, and that's fine. If a seller has any concern about that, the seller should talk to his or her agent or attorney. I would go back up and note, in terms of I've got married, if the buyers are a married couple, then it helps to go ahead and designate that. The reason being that when the deed is prepared, there's special legal protection and a special form of title if the buyers are married, and this helps trigger that so that when the deed is prepared, it's included. In terms of additional resources, again, there are specific GetSmart segments on estates, and from that, as you know, an estate is as a seller, and from that segment we divided up into specific GetSmart segments on heirs, executors, and trusts and the like, because again, that gets pretty complicated and it's beyond the scope of one particular GetSmart segment. So that's all I have for today on the parties. Feel free to contact your Liz Moore and Associates agent if you have any additional questions. Thanks and have a great day.
Be sure to subscribe and turn on notifications for our next installment of Get Smart with Brian Lytle.